I think the biggest concern that 21C has is that which has also been expressed by AIPLA and pharma and some other stakeholders, and that is whether these proceedings are providing the level of due process and fairness to all parties in them that they should be. These proceedings are different than the proceedings that previously were conducted by the Patent Office for interferences, in that in interference proceedings, the aggrieved party, if someone was unhappy with the outcome, they could appeal under Section 146 for a trial de novo in the district court. Here, there is no opportunity for appeal trial de novo, which means that the due process obligations of the Patent Office are much greater because there was a remedy in the past for interference proceedings that isn't available to people in PGRs and IPRs. So as a result, due process and fairness is much more important because, of course, these proceedings are intended to assess and affect patent owners' property rights. And as such, due process is required of administrative proceedings.
Now, we know, and we'll get back to some of these other issues in a moment, but sticking with this point for a moment, Phil, we know that the statistics indicate that only 30% of the claims that are challenged, or maybe 20% of the claims that are challenged in these new proceedings in IPR, are not instituted for trial. So we know that 70 to 80% of the challenge claims are instituted for trial, and that goes across technologies, and we've seen over 2,500 of these filed so far, which is a much greater number than anyone was expecting back in 2011 when you and I and others were working on the legislation. The question that also comes up is that only about 30% of the claims on average that are instituted for trial are found to be patentable, which is the way the PTO looks at it because they review it in de novo almost once they get instituted. Do you think that those statistics indicate a system that is fair under due process, or do you think those statistics are a red flag that there's something wrong?
Well, it certainly is skewed compared to what I think people anticipated when the AIA was under consideration. But I don't think from the statistics themselves you can necessarily draw the conclusion that there's unfairness. I think you have to look behind the statistics in order to see whether or not these proceedings are being conducted in a fair way. And so certainly I think that they suggest to anyone that they should be examined closely because, of course, the Patent Office has examined the patent applications and allowed the patent applications. So you would start with the presumption, as the law would require, that patents are presumed to be valid, that the Patent Office is presumed to have done its job. So when you see proceedings coming out with a very high success rate for the patent challenger, you ask yourself, were these patents that were challenged simply the bad patents out of an otherwise good lot? Is it selection by the petitioner, or were they good patents and bad patents which ended up getting put into a procedure that was not fair for one reason or another to produce results that would have been different than the results that we see when the same types of patents are considered in other fora. So we have two comparator fora in terms of statistics. One of them is the ex parte reexamination proceedings, which have been conducted by the Patent Office for quite a while. And they are similar in that they look at the same types of prior art as IPRs do. Both of them are limited to patents and publications, and presumably, since that is the evidence that's involved, they would be pretty good comparators. In addition, in reexaminations, the broadest reasonable interpretation of the claims is used by the Patent Office, which is similar to what is being done in the IPR proceedings. And so you would think that there would be some correlation between the outcomes in the two proceedings if they were both being done well and fairly. But I believe the statistics are that the invalidation rate in IPRs is more than twice the invalidation rate in ex parte reexaminations. So that's certainly something that would make you want to look further. The other benchmark that we have, of course, is what happens when patents are challenged in the federal district courts and on appeal, and there the rates are also much lower than the rates of invalidation that we see in the IPR proceeding.